This is In the Loop. I'm Christian Bryant. Tonight we're talking about a surprising pattern emerging in mass civil cases against major companies. Big names like Purdue Pharma, Johnson & Johnson, and 3M have become embroiled in high-profile lawsuits. But it's their response to those lawsuits that's getting a lot of controversy. Namely, each of these companies seem to take a page out of Michael Scott's book from The Office.
Bankruptcy, Michael, is nature's do-over. It's a fresh start. It's a clean slate.
Like the witness protection program.
Exactly.
Not at all. I declare bankruptcy!
Michael may have been onto something there. Today, we're going to talk about something that sounds kind of complex, but is crucial for understanding how companies can dodge legal consequences. And it's a process that's getting more common. We're talking about when companies declare bankruptcy in the face of major civil lawsuits. While these companies sometimes argue that declaring bankruptcy makes things more efficient for getting payouts to plaintiffs, critics of the practice say the process is being used to skirt accountability and halt legal action. So, how does that work? First, let's start with what actually happens when an entity declares bankruptcy, which does not involve just announcing it in an office. When a business in debt files for Chapter 11 bankruptcy, it allows the company to reorganize itself. The company sells some or all of its assets in order to stay afloat. A crucial piece of this is a process called an automatic stay. It basically halts any actions the creditors can take against the group in bankruptcy, like further lawsuits. This piece is the key to the controversial bankruptcy practice we've been seeing, sometimes called the Texas two-step. The Texas two-step works like this. Step 1, a company splits itself in two. The company then dumps all of its liabilities into the new entity while holding onto all of their original assets. Step 2, the new entity then declares bankruptcy and gets a shield against any further action from the creditors or plaintiffs. The big original company no longer needs any restructuring, while that new, smaller company becomes responsible for paying back the debts or settling lawsuits in bankruptcy court. This process is nicknamed after Texas because the practice has been legal there since the 80s, although as of a few years ago, it's been joined by Delaware. But outside these two states, this move would actually be considered a fraudulent transfer. That hasn't stopped major corporations from trying it. One major example is the ongoing case with Johnson & Johnson. Late last year, Johnson & Johnson used the Texas two-step to block about 38,000 lawsuits related to claims that its talc baby powder had cancer-causing asbestos. Just days after their new spin-off company, LTL, was formed in Texas, the new company declared bankruptcy. A U.S. Court of Appeals is currently deciding whether LTL's bankruptcy was filed in good faith and whether it should be allowed to protect Johnson & Johnson from any lawsuits involving talc powder. And remember, in many of these cases, time is precious. Many plaintiffs are cancer patients who cannot afford to wait for the case to end to see justice. The New Yorker estimated that in the 11 months since Johnson & Johnson filed for bankruptcy, an average of one plaintiff a day has died waiting to see if their case would ever be heard. A company attorney argued this would actually benefit victims by producing a faster settlement instead of letting the cases play out in civil courts. They also claimed that playing the cases out in civil court would reduce the money available for payouts. But Reuters says internal documents they reviewed show an internal team was formed to halt all lawsuits and move all cases to bankruptcy court to keep plaintiffs competing for a more limited pool of money. Sometimes this process isn't playing out between one major company and a new subsidiary. Wealthy individuals or groups can use the same bankruptcy strategy. This past summer, conspiracy theorist and internet personality Alex Jones filed for bankruptcy in Texas. This was after he was ordered by a jury to pay the parents of a child killed in the Sandy Hook school shooting nearly $50 million. The parents allege that Jones's claims of debt and inability to pay the families is fraudulent. And in another example, in 2019, Purdue Pharma declared bankruptcy, facing a wave of lawsuits for the company's responsibilities for the opioid crisis and their distribution of OxyContin. A settlement was reached at the end of last year, but in this case, rather than use a subsidiary, Purdue is required to pay about $6 billion in damages. The only catch, the Sackler family itself, which owned Purdue, will be protected from any future liability. Some lawmakers have been drawing more attention to the controversial bankruptcy cases, especially in the wake of Johnson & Johnson's filing.
So far, this trick has hit asbestos victims, but once the two-step strategy catches on, it could deprive all sorts of victims of the compensation they're due. Hiding assets in a bankruptcy is a serious wrong.
As major corporations keep a close eye on the outcome of these cases, perhaps momentum might also be growing for reforming the bankruptcy process for good. To talk with us more on reforming the bankruptcy process, we're joined here today by Bruce Markell. He's a professor of bankruptcy law and practice and a former bankruptcy judge himself. Bruce, thank you so much for joining us today. First and foremost, let's talk about what seems to be working in bankruptcy systems. What protections currently exist for the creditors when a company declares bankruptcy? And further, what sort of powers do they have to make sure they get their money back while companies sort out their finances?
Those two questions could kind of consume my entire bankruptcy class. Basically, most people will call bankruptcy kind of a fishbowl. That is to say, there's a lot of transparency. Bankruptcy debtor has to list all of its assets, all its creditors. It has a fairly efficient claims resolution process that can determine whether someone's claim is valid and should be paid, and also how and when. It's a very responsive system. Even in the large mega cases, you get faster reactions from the court than you would in most other courts. Right.
Some companies like Johnson & Johnson have been accused of using bankruptcy courts to slow down the process of paying back lawsuits. But their company reps have argued it's the opposite, that bankruptcy court would actually get money to people faster. Which is it exactly?
People can have a legitimate debate about that. In my view, what Johnson & Johnson has done is basically to say, we want to distribute, we probably owe money to people, we want to distribute it on our terms, not the terms that everyone else is subject to. It created a subsidiary, dumped all its liabilities with respect to the talc into that subsidiary, and then tries to use bankruptcy for that. Now, bankruptcy as a means to resolve so-called mass tort cases where there are, one entity has caused a lot of injuries. Using bankruptcy for that it's kind of like if I see a nail and and it's sticking out and I want to hammer it down, but all I got's a screwdriver, and I use the screwdriver to kind of bang it down. It's not going to do a pretty good job of banging it down. It's probably going to destroy the screwdriver at the same time. And that's kind of what's happening here. It's that people aren't particularly happy with the existing tort system. And so they want to go to a different system, bankruptcy, that they can control more. But the system was never designed to handle this type of mass tort issue. What it has done is to avoid the fishbowl. J&J caused all the problems with its talc, if in fact that is what happens. But now it gets to move the liabilities, but not its assets, to the fishbowl. And that's a problem. All they have in bankruptcy is J&J's promise to fund the process without necessarily any guarantee that what they would get in bankruptcy would be the same thing they would get outside of bankruptcy. If they have more assets and liabilities, then the creditors ought not to take less than 100 cents on the dollar. I'm not sure that's what's going to happen in J&J.
Bruce Markell is a professor of bankruptcy law and practice and a former bankruptcy judge. Bruce, thank you so much for your time and your expertise, my man.
I appreciate it. Thanks for inviting me.